Welcome to Kanooni CHARCHA. Today I have again with you topic of discussion would be today this concept of anticipatory bail, how it evolved, relevant provisions of earlier criminal procedure codes and now new BNSS 2023 and I will also discuss, delve upon in new judgment on this question, on this topic. There is a new judgment of first week of I think September, very recent time. Dhanraj, Ashwani and Amar versus Amar Chand, Mool Chandni. This is the judgment of Honorable Supreme Court of India. The question before the Supreme Court of India, the question framed by the Supreme Court of India for its decision, there was a judge bench. Dr. D.Y. Chandrachud, Honorable Chief Justice of India, J.Y. Padriwala. I think he has authored this judgment, and Justice Manoj Mishra. This judgment is dated 9th of September 2024. I have already said first week. A question of public importance was framed. Now, earlier the High Court of Adjudicator of Bombay, a objection was raised as to maintainability of anticipatory bail with regard to a case where the accused is already in custody in some other case. Bail is being claimed in another case where the accused has, regarding which the accused has an apprehension to be get arrested. This is however, he is in custody in some other case. He is there. Sometimes you might be knowing, viewers, that there are multiple FIRs against a particular accused, a man, a person. Then point I will refer here for the convenience of the viewers or otherwise for the information. Whether a person, while in custody for a particular offence, can have a reason to believe that he may be arrested in relation to some other non-bailable offence. What is the definition of Section 437 of Code of Criminal Procedure? This was earlier available before coming into force of BNSS. You are knowing, viewers, that from 1st of July 2023, the 2024 BNSS of 2023 came into existence. Earlier, there was provision with regard to anticipatory. Similars are being repeated in BNSS also. But prior to 1973, there was no any provision, concept of this anticipatory bail. Now, what is the important ingredient of Section 437? You may say, or 482, I think, of BNS corresponding section, which is now in Bharatiya Nagrik Suraksha sign. What is the there you will find that there is a reference, a person, if he believes, there is a reasonable belief belief to him that he would be get arrested in some offence, then he can apply for anticipatory bail. Anticipatory bail means bail in anticipation of arrest. But in this case, I have referred, which I am going to delve upon the judgment. This point has been raised that whether a person already in custody in some other case can claim bail in anticipation of arrest, regarding which he is apprehending his arrest in another case, earlier registered or subsequent to be get registered, about whom he has the concerned has the apprehension to be get arrested. This is a point to be discussed here, discussed in this judgment. Now I will come that you might be knowing, or otherwise there is a provision that production warrant can be sought by the police of an accused if he is already in custody, or otherwise also if he is not in custody. Then after production warrant and his production before the concerned magistrate or judge, the remand is granted. This is required. The personal presence of the accused is imperative for grant of remand. Now, if this can be allowed as per the relevant provisions of the Code of Criminal Procedure, or subsequently now this applicability of BNSS, you will find similar provision that police or whosoever agency, any other agency whose investigating some matter can get the remand of the people, person, the accused who is already under arrest. So if that can be granted, protection for the vice versa is that if production warrant can be granted by a magistrate or judge and thereafter remand, so why not anticipatory bail in such a case? In such a case where the accused has a reasonable belief that he would be get arrested. This is a question involved. This the relevant para, this point the relevant para of the judgments, I think the advocates are Siddharth Luthra. He was the counsel for the appellant, who he is from the complainant side, because earlier his objection as framed by the Honorable Supreme Court of India was overruled by the High Court of Judicature, Bombay, and Siddharth Dave is the advocate for the respondent. Now I will go directly to relevant paras of this judgment in order to discuss further about this point which has been framed, and how the Supreme Court of India, the three judgments have decided this issue, this point, this question of law. This is not this why the three judge bench was constituted, because there was earlier a decision, Narindersingh, and which is somehow confusing. No doubt earlier there was a conflict of judgments of various high courts. Some allows that some allows the taking of remand. Taking this grant of this anticipatory bail, even if the accused is in custody in some other case. If he apprehends, the other judgments are not in favor of this concept of law. Now, now I will go directly to para, I think 63 of this judgment, which is very much relevant to this point raised and discussed by the Honorable Supreme Court of India. Para. Now they have discussed Article 21 of the Constitution of India with regards to the right of personal liberty. There are many judgments have been discussed in this para 61 contains judgment discussed. Some judgments are in favor and some are in dispute. But now I will come to relevant para 63. There was a divergence of opinion, and in Narindersingh sahni, which I sahni SAHNI, I will read out for. It was also sought to be argued by Mr. Luthra that the issue at hand has already been dealt with and decided by three-judge bench of this court in Narindersingh sahni. Mr. Luthra was advocate of the appellant. It was contended by him that the dictum laid therein is that an anticipatory bail filed by an accused in different case while he is in custody in one case would not be maintainable. This is appellant's contention. A similar contention was before the High Court of Bombay, which was overruled by the Bombay High Court. However, we are unable to agree with such a submission of appellant. In the said case, the petitioner therein, who were arraigned as accused in multiple FIRs, as registered at various police stations across the country, had invoked the jurisdiction of this court under Article 32, praying for an order for bail in the nature as prescribed under Section 438 of Code of Criminal Procedure. The crux of grievance. What was the grievance of the petitioner in Narindersingh case? Now, that was that although they had secured an order of bail, in one case, yet they were being detained in prison on the strength of production run in another case. Virtually, what happened? The production brunt was already made operative and accused was detained accordingly. Now there was a bail order that obviously that has become infructuous. Now I will go further. This accordingly to the petition was violative of Article 21 as they were deprived of their liberty despite having been granted bail in one of the cases. But now the aforesaid contention, this is para 64. This was the contention of the Mr. Luthra and how this was dealt by this three judges bench. The aforesaid contention of the petitioner in the said case was ultimately rejected by this court, Honorable Supreme Court, on the ground that even if the petitioner could be said to have been deprived of their liberty, such deprivation was in accordance with the law because on the production grants issued by it, that a due course was adopted. Having observed that this court dismissed on that basis a writ petition filed by the petitioner for this infraction of Article 24 was not established. This is now come to para 65. Evidently, this court in the aforesaid case had no occasion to go into the question of maintainability of an application for grant of anticipatory bail by an accused who is already in custody in relation to some offence. This question was not earlier dealt with in Narindersingh, in Narinderjit Singh Sahni's case. This is observed by their lordships in para 61. This is now. Let us come to para 66. On the other hand, in the present case, we have decided the issue of maintainability of anticipatory bail application filed at the instance of an accused who is already in custody in a different offence, have reached the conclusion that such an application is maintainable under the scheme of CRPC. So now, at that time, the provisions of earlier Code of CrPC Bail were applicable to that. Now, they have said that the question raised, framed, was answered positively, that bail can, anticipatory bail can be claimed if, in an offence, apprehension of arrest is some other case from the case in which he has been arrested, earlier arrested. However, it is clarified that each of such application will have to be decided by the competent court on their own merits. Now, question arises. It is now clear, this point is clear, that anticipatory bail can be claimed and granted in a case regarding which there is an apprehension of arrest of a person. No doubt he is already custody in some other case. And I will repeat here that the police has a right, empowered to get production warrant if the accused is already in custody for have arrest, have a remand in some other case. It means when such a right is existing, is with the police of arrest, remand, and this you may say this remand, production, remand, and arrest. Why there should not be a corresponding right or to avail anticipatory bail? This is the crux of this judgment. The point, the Article 21 gives a right. There is no only, but the section says there must be a reasonable belief that a person would get arrested in some offence. It is not that he may claim bail if he is not already in arrest. The law is very clear. This section is very clear. 438, now 482, I think, corresponding of BNSS. Now, this is the law. But now a point in this judgment was raised by that if he is already in arrest, he can claim bail in some another offence which apprehension of which of arrest he may have. The answer is in affirmative. This is the crux of judgment of judgment in case Dhanraj Ashwani versus Amar S. Mol Chandni. This is a dated, judgment is dated 9th of September 2024. I think very short point and very important point. There was a earlier conflict and divergent of opinions of the various high courts, and Narindersingh Sahni case was referred by the counsel for the appellant, but it was distinguished by the Honorable Supreme Court, the Lordship of the Honorable Supreme Court of India. I think this is sufficient for today. Again, I will with you with a new topic, new judgment of Supreme Court of India or from any other important, any other high court. Thank you very much.